section of Civil Rights and Social Justice Vice Chair, and I will serve as your moderator for today's session, Panel 4, From Incident to Impact, a Practical Blueprint for Litigating Civil Rights Cases. I'm sitting in for our CRSJ Council member, Dominique Calhoun, who sends his deep regrets as he has had unanticipated delays due to international flight cancellations. So we're thrilled to have you join us for this national virtual conference, bringing together advocates, attorneys, scholars, and community leaders committed to advancing civil rights and social justice. Civil Rights Boot Camp was designed as a practical resource for young lawyers, law students, public service attorneys, and advocates of all backgrounds, offering a real-world insight and strategies for navigating today's civil rights challenges. We hope you'll stay with us throughout the program. We have a stellar lineup of panel and speakers across the boot camp, and a quick few housekeeping notes before we begin. Please submit your questions using the Q&A function, not the chat. We'll monitor questions throughout the session and address as many as time allows. If you don't see the Zoom controls, chat, Q&A, or captions, try moving your mouse or tapping the screen to make them appear. We want to note that this is not for CLE credit. Today's session is being live streamed for CRSJ's YouTube channel, where it will remain available for on-demand viewing shortly after the program concludes. A recording will also be shared with everyone who registered, so please feel free to forward it to colleagues and networks who may benefit from this discussion. We also encourage you to explore the Zoom events lobby, which serves as the central hub for the boot camp. There you can view the full event schedule, access sessions, recordings as they become available, and explore speaker and sponsor information, connect with other attendees, and find additional bootcamp resources, materials, and announcements. The section of Civil Rights and Social Justice regularly provides free webinars and resources for legal professionals and advocates nationwide. We hope these tools support you in your work. And to learn more or to become involved, we invite you to visit americanbar.org/CRSJ and consider joining the ABA in the section of Civil Rights and Social Justice. So now let us get started. I am pleased to announce today's speakers, who will begin by providing a brief introduction of themselves, including their background and the work in this space that brings them to this discussion. And they will begin in this order. It will be Brooke Cluse, who is Chief of Staff for Ben Crump Law. It will be Demario Solomon Simmons, Founder, President, and Chief Legal Counsel for Justice for Greenwood. And Paul M. Smith, Senior Advisor and Visiting Professor, Georgetown Law, and Chair-elect of the ABA section of Civil Rights and Social Justice. So thank you to each of you for providing us with these self-introductions, and we will begin with you, Brooke.
Thank you, Dr. Swan, and good afternoon, everyone. I feel honored to be with you this afternoon, so I hope that I can share some information that will be helpful. My name is Brooke Cluse, and I am an attorney and chief of staff at Ben Crump Law, and I live in Houston, Texas. My initial foray into civil rights litigation was in Houston with the Harris County Public Defender's Office in the Felony Trial Division. And that was one of the most rewarding and benefiting jobs that I've ever had in terms of helping the least of these. The cases that we were assigned were not cases that we could choose. And so we had to help defend those that some may even have thought didn't deserve a defense. But that is the beauty and the most important facet of civil rights litigation, is that even those people deserve defense and constitutional protection. And having done that for several years, I just so happened to run into Attorney Crump in the Harris County Criminal Courts. And he was supporting a family who was there for a police officer who had been on trial. And, basically just, walked up to him and shot my shot because ultimately my goal was to be a civil rights litigator with Ben Crump Law. He didn't know that, but I knew that. And so, as luck would have it, and maybe God, he allowed me the opportunity to join the firm and prove myself. And so I have two jobs essentially. I am an attorney handling cases. And primarily focused on environmental justice cases. But because I'm his chief of staff, I get to view and have background knowledge and behind the scenes access to all that he does on a daily basis, which is for the average person would be eye-opening. And it's oftentimes I look at him and wonder how he can keep up with the amount of work that we have, amount of cases that we get and calls that he gets, and all the other things that he has going on. So it truly is, I think, my call to be in this type of work because um, civil rights is under attack right now. I honestly didn't think we'd be in this position today in America, but it seems like more now than ever, we need civil rights attorneys who will stand up for the Constitution and for the citizens of the United States. And so that's why we do what we do. And that's why I get up every day and work very hard as both the attorney and chief of staff to make sure that we can protect our clients and protect the Constitution. And that's all I have in introduction.
Thank you, Brooke. Demario?
Thank you.
Yeah, and I can attest that Brooke is the truth. I've worked with Brooke on many things, so she's telling you the truth. So
Thank
listen,
you.
I'm attorney Demario Solomon Simmons. Law is my ministry. Justice is my passion. I'm based here in Tulsa, Oklahoma. I've been practicing about almost 22 years, primarily in the areas of civil rights work. I've done a lot of police brutality cases, police shooting cases, done a lot of civil rights work in other places in the sports law arena. Now, the last 7, 8 years, I've been really focused on the work of the Tulsa Race Massacre. I represent the last living survivor of the Tulsa Race Massacre, which is 111-year-old mother Leslie Benefield Randall. We recently lost our other survivor, Mother Viola Ford Fletcher, last November. She was also 111 years old. So really been doing a lot of work around that, trying to get them justice before they leave and representing hundreds of descendants. Also, I'm a Black Creek Indian, and so I'm also the legal counsel for what's called Creek Freedmen, which is about 100,000 Black Creek Indians who've been disenfranchised of our citizenship through the Muscogee Creek Nation. We had a big victory in the Muscogee Creek Nation Supreme Court last July. And yet, over 8 months later, we are still fighting for that victory to be implemented. Actually, we just filed last Monday a preliminary injunction to stop some elections that's going on. And we're very excited because Legal Defense Fund and Lawyers Committee has joined our work and has filed an amicus brief on our behalf. And then so I'm a litigator, but I'm also have an organization called Justice for Greenwood. And not only do we do the litigation aspect of it, but we also do oral histories and genealogy work, because we believe very strongly in anything with civil rights, you have to have a strategy beyond the legal. And I know Paul and Brooke know what I'm talking about. Anything with civil rights, you pretty much got to have a three-pronged strategy. And Ben does this tremendously well. You have your litigation or your legal strategy, which is also it's litigation, but it's also the legislative strategy. Number two, you got to have a narrative strategy. You have to win the narrative battle. And that is an ongoing deal you have to do each and every day. And number three, you have to have a community strategy. And that's mobilizing. First of all, it's galvanizing, organizing, and mobilizing the community to be a part of your claim. So I'm excited to be here. I'm thanking the American Bar Association for this opportunity. Appreciate Dominique for inviting me. I know he's having some travel difficulties. I'm looking forward to the conversation. And Paul, I'm familiar with your work, so I'm honored to be on the panel with you also.
Thank you.
Thank you, Demario. And Paul?
Thank you, Cynthia. Hi, everyone. I'm Paul Smith. Happy to be here and happy to be speaking on this remarkable panel. I was a litigator for about 45 years, much of that time in private practice at a small firm and then a big firm. And the last 8 years, I was at a nonprofit litigation shop called the Campaign Legal Center that focuses on voting rights and gerrymandering and the like. And throughout the sort of type of civil rights lawyer that I think I want to talk about today is what I've been for that almost all of that period of time. When I worked on a whole variety of issues, both in the trial level and up in the Supreme Court. I've argued quite a few Supreme Court cases over the years. And so on issues like LGBTQ civil rights, I did a big sodomy case, Lawrence v. Texas in the Supreme Court, marriage equality issues and the like. Another big part of my work has been voting rights and redistricting, both at the firms and then more recently at the Campaign Legal Center. A lot of First Amendment challenges. And if you go back far enough, cases about the constitutionality of state systems of service for people with intellectual disabilities and mental health problems. The thing that all of that work has in common is that what we were seeking was not damages for a specific thing that happened in the past, as Ben Crump's firm often does, but injunctive relief, trying to fix a problem often for a very large group of people, challenging the constitutionality of a particular state or federal statute or state or federal policy, or in some cases, if you go back to the institutional litigation, trying to fix an entire department of state government that was operating in a deficient manner. And this kind of injunctive relief is the kind of thing you don't see done in small civil rights firms. It tends to be done at big firms like the one I was blessed to practice at, Jenner & Block, and in specialized nonprofits like the Campaign Legal Center, or often they're partnered together. These are big, long, slog kinds of cases requiring a great deal of resources and experts and the like. And they have certain things that in common. One, you get to design your case. You get to go out and find your plaintiffs. And so you have to make sure you have the right kind of plaintiffs who will represent the cause, be part of that public narrative that DeMario was talking about, be able to sort of communicate by their very essence the message you're trying to communicate. And of course, you also have to make sure they have standing. Another big part of this kind of litigation is that you have to plan for the appeal from the very beginning, because it's not the kind of case that's going to get settled. The government very seldom is going to file a settlement agreement saying that a statute's unconstitutional or their policies have been unconstitutional. They're going to wait to see what a judge says, and then very often there's a tremendous amount of pressure on them to, if you've won, to bring an appeal up to the Supreme Court. And so you have to recognize that and be ready for it and think about issues like standing. Should it have been done as a class action, or is it okay just to have an individual challenge to a statute and the like? These are all very complicated matters, but it is an enormously important part of the civil rights fabric, the kinds of cases that have brought, for example, marriage equality and some improvement on voting rights. More recently, it's been a tough slog in that area and the like. And so I'm happy to talk more about that as we continue this conversation, but that's basically what I'm here to talk about.
Well, thank you. Thank you to all three of you for your introduction. It's wonderful. And so I'm going to start with you, Brooke. So let us begin there by turning to the role of individual harm in shaping civil rights advocacy and the importance of a client-centered approach to this work. At its core, we know that civil rights practice is grounded in the lived experiences of individuals, those directly impacted by injustice, and it's through those experiences that broad patterns of inequity are revealed and addressed. So, Brooke, when an individual first comes to you after experiencing a civil rights violation, what does justice typically mean to them? And how does that for you evolve into litigation?
Sure. So when an individual comes to us, justice typically means our equal accountability. They want someone to face accountability for the harms they've experienced. And most times, believe it or not, they want a criminal prosecution. And where we come in, because they do come to us, we have to ultimately explain the entire process to our clients. So it's an education piece, but keep in mind that initially they're in the throes of a traumatic experience. And it takes a lot of, hand holding to get them through this process. So initially, they're saying we want these criminal charges, we want this, we want that, and we understand that, and we advocate for those criminal charges with the at fault parties. However, we have to also educate them that while we can advocate and we do zealously advocate, those aren't our decisions. And so where we come in is then providing that recourse for civil justice. And again, I say, we want to provide or make it unsustainable for these harms to occur by getting monetary justice. But our clients don't even want that, and it's not top of mind at the time. Eventually, they'll get to a place where that'll provide them some level of feeling like they have received accountability and justice. But it just evolves over time, because what they want is someone to pay in the criminal courts for what has happened to their loved one. And I'm speaking specifically excessive force, police brutality cases. Our other cases are a little different, but when we talk about what people know Attorney Crump for with the civil rights cases is that, they want accountability and they want it in the criminal courts. But what we provide is the fight in the court of public opinion that can hopefully get the attention of lawmakers and the courts, and that we can get the type of justice that they seek first, and then transition and move into the place where we can get them the civil justice that they also can desire at the same time. So it is an evolution. The whole process, because it's just not one thing. And all of our clients, they're all multifaceted. And a lot of them have backgrounds that may not be pleasant as well. So we just, each individual client is handled in an individualized way. And Attorney Crump takes very seriously each case. And we work very, very hard to get them from the first stage of that case, which is the intake and that initial process of getting to know them, to justice and accountability.
If I could I just jump in on that, because Brooke hit everything right. I think another thing when you're dealing with a case, just say civil rights, say an employment case or something like that, people are also looking to have someone advocate on their behalf and for them to be heard. Because many times people are suffering these harms in silence. They have very little power at their job. I have a case right now where we filed a case. We have a 7-year-old young man that was brutalized at school by a paraprofessional teacher. His grandmother has adopted him. She really didn't know where to go. They feel like they just got swept underneath the rug, and they really want someone to stand strong for them and get their narrative out. And that means more to people than people understand, to have someone actually speaking for you. And that's why, people like Ben and Lee Merritt and other guys I run around with, that's why they get those calls, because they stand there. And Brooke said something that's so important, I really want to highlight. We fight as civil rights attorneys for things that we don't get paid for. You don't get paid to make them go get a criminal decision. You don't get paid to do all the press conferences. You don't get paid to go and show up at all the different places to get the narrative out. But that's part of the civil rights work if you're really dealing with regular people, what we call sometimes, as a street lawyer, right? People that's walking in off the street, they just had an issue and they need somebody to advocate for them. So if you're getting into this area, understand that this is something you have to have a real heart for, because while the big cases, and obviously Ben is huge, I've had big cases, but most of civil rights work is not that. It is mostly grinding for years, trying to get someone some justice, and you have to have a real love about what you're doing.
Okay, so as we are talking about and navigating the emotional toll that we know starts to prepare the case, and we also take in things such as intake, evidence preparation, and framing, all of these things help shape the legal strategy. And of course, we also know that you also have to determine how you're going to engage media and how those decisions affect your client. So when you're building the case, how do you craft a narrative that resonates with the courts, the public, and the policymakers? Because we are talking about going beyond the emotional that we know they came to us with, going to the next level of actually framing a case and having the legal precedent in which to move on. So how do you begin to bring media into that, the courts into that and coming up with legal doctrines and structural barriers, let's say, or removing structural barriers to having a successful case. And this is for you, Brooke.
Okay. All right. So first, it begins with the intake. This is highly important when you're dealing with specifically 1983 cases, because we have qualified immunity and we have to vet the case and get all of the information that we can get. And so we are diligent in our investigations of all of these cases. We want to know the facts. We want to know the good, the not so good. And we want to know if there's smoking gun evidence, because you almost need it in these civil rights cases. So that's the first part. And so once we identify a case that we can move forward with, and I'm sure you already know, we get so many calls. So we probably only take a fraction of the cases that come through the door because we just, cannot take them all. But we're looking for cases that will impact the broader community and hopefully, make positive change. And then also the cases that may shock the conscience. So once we've identified that case, obviously, Attorney Crump has perfected the ground game when it comes to advocacy in the court of public opinion. And so we start to craft the narrative of our client and get them ready for the media. And remember, I highlight this all the time because our clients are traumatized. They don't think straight when these things happen because they are managing so many different emotions. You think Breonna Taylor's mother, you think George Floyd's family. You can only imagine, especially when there's a public harm, that people have seen the type of trauma that comes with these cases. And so after we move from, intake to, we're taking this case, we're going to, craft our narrative. And that again comes from the background work that we've done with talking to the family, engaging with the community early on, having all of the facts behind us that we need, and even the things that may not be the most positive information to share, we're ready for that stuff. And so while Attorney Crump is ready to have his narrative and get into the public and fight in the court of public opinion, we also prepare our clients, because with that media opportunity also comes scrutiny. And so we want to prepare our clients for when those interview requests come, and for how to stand firm in, this process when it comes to the media, because the media can be great, but it can also be detrimental to the case. So we have to be prepared in all facets of the case. And that's what we do. And so then that's part of the strategy. And so when you think about George Floyd, they really wanted to hone in on, his, perhaps alleged drug use, but that wasn't the story that we fought for. We crafted the narrative that he was, the cop had the knee on his neck for 8 minutes and 29 seconds. That is something that I think Attorney Crump has said that a million times, because that's what the focus is. It's about his humanity. And so our goal from that's all a part of our strategy. And so that was probably one of the most successful cases that I've seen in, my career, because of how well executed that court of a public opinion strategy happened. Because then when we moved into the court of law, we saw things happening that we, hadn't seen before. The way they brought in Mr. Ellis to prosecute the case, or excuse me, the attorney that prosecuted the case, Keith Ellison, yes. He was the AG. So he did what needed to be done in that case. And the case against Mr. I can't think of his name, the cop, he was found guilty. And that's something that we didn't expect to happen, right? We think about these cases, and more often than not, in the case that I even met Attorney Crump when he was in Harris County, that officer was found not guilty when there was clear video of his egregious behavior in killing Pam Turner. That was the case that happened there. And so that whole strategy is important because the community was galvanized. I mean, I think the world, actually, I would say, because they saw what happened. The media strategy took hold. The court of public opinion advocated just as hard as Ben Crump did, and all the other attorneys, for the family. And so that translated into a victory into the courts. And then when you think about the settlement that ultimately happened in the civil court, the reforms and the lawmakers that are engaged in trying to help these families not to relive what the Floyd family relived. And that's the whole, I guess the whole strategy essentially is from intake to settlement or trial. It's engaging each piece with a very strategic focus on engaging the community, engaging the family if they want to be out front in the cause and in the fight, and then also engaging other attorneys as well. So it's not a one-pronged effect or situation. It involves a lot and a lot of strategy and a lot of deliberate focus on the court of law, the court of public opinion, and advocacy in the larger community.
Okay, thank you, Brooke, for those remarks and for really grounding this conversation around courts, the media, and public, as well as policymakers, and how
Yes.
all of this contributes systemically in a very important way. And so now I'm going to move on to Demario, and let us turn to that long arc of civil rights, one that requires us to confront historical harm, engage seriously with the concept of reparative justice, and consider how modern advocacy carries that work forward. This is not simply about looking back, but about understanding how past injustices continue to shape present realities, and how to sustain civil rights practice, how a sustained civil rights practice must grapple with both legacy and lived experiences in advancing meaningful accountability. And so with that in mind, your work, Demario, often addresses harms that are not just individual, but generational. And you spoke a bit about that, but can you translate historical injustice into a legally actionable claim for today?
Well, thank you so much for the question. And a lot of my work, I was just joking this morning at the gym. I said, my wife thought she was going to be marrying a wealthy, attorney, and she married a civil rights attorney that focuses on historical harm. So bless her heart. Pray for my wife, Mia Fleming. Listen, the thing about it is when you're dealing with these historical harms, and I'm a forensic historian, I consider myself, or amateur forensic historian. I have a degree in history. So I love to use history to bring these harms forward. And one thing that I'm always explaining to people, that we're not talking about something that just happened in the past. We're talking about the continuing harm. And that's a word I'm talking about all the time, the continuing harm of something. So, you have to be very clear. Again, that's what your narrative standpoint. And you have to understand, as a civil rights attorney, you cannot be afraid to be creative. You cannot be afraid to be wrong. You cannot even be afraid of a Rule 11. You have to do what you feel is necessary to get the issue out there moving. So I have a lot of cases where there isn't really a quote unquote a legal theory in and of itself if you just go by the books. But if you really just dive into it, start talking about equitable relief, you start talking about the continuing harms, you're talking about, like we use here in Tulsa, the public nuisance litigation, where we made the argument, I think we did it quite well. And we made the argument that that nuisance that started in 1921 because of the Tulsa Race Massacre continues to this day. And we're able to show the facts and figures about that. Unfortunately, our Oklahoma Supreme Court literally changed the law just for our case and dismissed us out after our hearing. But the fact of the matter is, you have to continue to push the issue. And so I had a case I was consulting on just recently out in California where African-American guy was successful, built a big home in this place. I think it's called Piedmont, California, outside of Oakland. And the white folks literally ran him off his property, took the property from him. And then this guy dies of starvation some years later. And so we're trying to figure out, how do we get this narrative going, and how do we make sure that people understand that this harm is ongoing, because the house that he built that's worth $3 million today is still there with people living in it, and they haven't even made any improvements to the house. Like, it looks the same way as when he built the house, right? So that's the continuing harm aspect of it. So you want to continue to make sure that, again, I know we keep harping on this, but having that narrative, having that community piece, but then do not be afraid in the courtroom. And I tell all people that go to court, all litigators or trial attorneys, when you go and you make that argument, you make the argument 100%, you believe in it. And to do that, you have to have preparation and you have to have confidence. And you cannot have confidence on your feet if you're not prepared. So this is this is a profession of the civil rights aspect that you have to really say, I want to do this. I want to take this on, because you have to be so prepared, because the system's against us, history's against us, the courts are They were already bad, and they're even worse now under this particular administration.
Okay, so you've listed some of the challenges that come with this, but you still have to build evidentiary support for the cases that you're developing. So when your traditional evidence is incomplete, suppressed, or lost in history, how do you begin to build that case?
Yeah, well, in many cases, that's actually evidence of the harm. That's part of the harm. Things were burnt up, things were burnt down. But there's ways to get it. That's why oral history is so important, right? The oral history is so important. That's why it's important to ask the courts. Like we were able to do some early discovery in our case where we said, hey, court, we got to do these depositions of our clients that are over 100 years old before they die. You got to be creative. You got to continue to push. You got to connect with organizations like what Paul works with or bigger law firms that has the type of resources so you can go and do the type of work that needs to be done. I work with experts all around the nation, law professors or professors at universities that are doing research. Dr. Nathan Nunn was one professor we worked with. So it's a lot of different avenues when you're talking about this particular historical type work that's necessary to build that historical record. And then, hey, get into the evidence, get into these hearsay rules, get into these exceptions, but don't be afraid to try something that's never been tried before.
Okay, so let's talk a bit about, we know that reparations is both a legal and a moral concept. What legal pathways currently exist for individuals or communities seeking redress for historical harms through reparations in its broadest context?
Well, I certainly want to hear from Paul a little bit, so I'm gonna keep this very brief. Reparations, there is no legal term, even though reparations is a well-established law, internationally known and established for over 500 years. And this country has paid reparations to so many different groups for the harms. They even paid reparations to enslavers. In DC, before the Emancipation Proclamation, they outlawed enslavement in DC, and they paid those enslavers who emancipated their enslaved people. So those precedents are there. There is no statute that says reparations. So again, you're looking to use the type of laws that are there. So in our litigation in the Tulsa Race Massacre, for instance, we did not use the term reparations in our 120-page petition. We talked about the actual claims of unjust enrichment and public nuisance, and those are the things you have to do. So this is a tall order, but again, we lawyers, listen, this is what we do. We figure out how to get around these challenges, and we can do that if we're just being creative. And this is something that I think about each and every day as I'm thinking about how to get around these issues. But I want to hear from Paul. We've been doing all this talking. I want to hear from Paul.
Demario, we are going to get to Paul. So we really appreciate
Thanks,
your
Demario.
remarks
I'm a fan here.
and the depth of thought and perspective, obviously, that you brought into this particular part of the conversation. And we would not ever forget to speak with Paul.
Don't worry.
Paul will address our next topic, which is focusing really on the growing significance of appellate strategy and driving national civil rights outcomes. As courts grapple with the scope and limits of nationwide injunctions, these questions are not just technical, they go directly to the heart of how and for whom civil rights protections are realized. So Paul, your work operates at the national level. How do you approach cases differently when the goal is not just individual relief, but broad systemic impact?
Right. Well, the kinds of cases that I talked about, I was lucky enough to work on, really are cases where there's a large group of people who have suffered a significant harm, but it's not like that one person who knocked on your door and said, I had this happen to me, you need to help me, be my voice, and that sort of thing. Just to take an example, one of the cases that I brought back in 2009 was a challenge to a so-called Defensive Marriage Act, which on behalf of married couples, same-sex couples in Massachusetts who've been married, some of them for 5 years, and still weren't treated as if they were married by their own federal government, costing them lots of federal rights. And so how do you bring that kind of case? You go out and you find plaintiffs who will be good spokespeople for the harms that a large class of people have experienced. and you try to craft a legal theory that you think can prevail where the case is going, which when you're challenging a federal statute like that is the Supreme Court. And then we had the good fortune of good timing. We filed this thing about 2 weeks after President Obama was inaugurated. And so I spent a great deal of time in 2009 talking to the Justice Department about why it was unconscionable for them to continue to defend this statute, which had no justification at all, why you should treat this category of married couples so much differently from everybody else and what the justification could possibly be. And eventually the combination of sort of public pressure, there were demonstrations on behalf of our cases, and internal pressure led to, in 2011, Attorney General Holder to announce that they were no longer going to defend the constitutionality of the Defense of Marriage Act, which was a great moment. And of course, it led to the appointment of somebody by the Republican House of Representatives to defend it. Mr. Paul Clement was then the lawyer we were up against, and it ended up in the Supreme Court eventually. And happily, in 2013, we had 5 votes, thanks to Justice Kennedy, our friend for LGBTQ civil rights. And that case became the precursor to the marriage cases that followed in the next couple of years, ultimately Obergefell. So it was a combination of picking plaintiffs that would be perfect, appropriate spokespeople, lobbying the Justice Department, and trying to get the public to be sympathetic with a group of people who were being mistreated for no reason at all. No, there was no justification. I hope that's a good example of the kind of mix of things you need, and then you bring in some of DeMario's enthusiasm and commitment, and then you have a good case.
Absolutely, absolutely. Historically, nationwide injunctions have been a powerful tool in civil rights litigation. Unfortunately, we are beginning to see some attempts to undermine that. Can you explain their significance and what is at stake with the recent limitations that are coming along?
Right. There was a big case this past year about birthright citizenship, and the challenge to the decision that was entered by the district court was this is a policy announcement by President Trump in an executive order that they were no longer going to read the 14th Amendment as allowing citizenship to people whose parents were here and they were born here, but they were not here legally. The district court had held that that's a misreading of the 14th Amendment, and the president has no power to amend the Constitution, which seems right. But had issued a nationwide injunction saying that the Trump executive order could not be enforced anywhere. And what the Trump administration did is they went to the Supreme Court and said, well, whatever the merits are of the birthright citizenship thing, one district court should not be ordering the outcome for the whole country. And the court ended up saying in only very limited situations should there be that kind of nationwide injunction against a presidential action like that executive order. And so they limited the effect of the injunction to the district where the district judge was. And so what that's done is put pressure on the alternative procedural device, which is class actions. So if you can get a class action certified, then and it's a nationwide class, then your injunction has nationwide effect. And so we saw almost immediately in these birthright citizenship cases that were percolating around the country, motions for summary judgment, motions for class certification. And this has caused some procedural complexity in these cases, but ultimately, hopefully, the lawyers are clever enough that they'll find a way around it, especially if the judges think that their order ought to have nationwide effect. Fortunately, a lot of the work that I've done over the years is at the state level. So it's a state statute, it's a state gerrymander, it's a state voter ID law. And in those kinds of cases, you don't get the same problem. And when a federal judge rules that a particular state policy or statute is illegal, it has full effect statewide. And so we haven't had to worry about that much. But this nationwide injunction thing is an interesting problem, and it's not entirely clear what the right answer is. That there were some of the more liberal justices also sympathetic to the argument that one district judge shouldn't be able to put an order into effect for the whole country, because of course they saw the same thing happening while President Biden was in office, and some of the more conservative judges around the country were issuing nationwide injunctions against his policies and executive decisions, and they didn't like that. So it's a complicated problem, but it is not a problem that's insoluble. The injunctions can be gotten, relief is available, and ultimately, as the case percolates up to the Supreme Court and you win in the Supreme Court, hopefully that will be the end of all of these concerns about the scope of the relief, because once the Supreme Court rules, the whole country is, of course, covered. There's a little civil procedure primer for you.
And we love it, especially when you think about class action suits becoming the vehicle, quite frankly, to move things forward. But when you consider that, what would you say are the areas of civil rights law that are most vulnerable at this point in terms of, where do you see opportunities for progress through class action and whatever other?
Boy, it's hard to be real optimistic about areas of civil rights law that can be won in these sort of large injunctive cases these days, given the court system we're dealing with, and the like. But I mean, ultimately, the truth is, I'm coming up blank on one where I could feel like I could go up to the Supreme Court with a large statewide or nationwide injunction and feel confident of the outcome right now. But that doesn't mean you shouldn't keep fighting. The wrongs are occurring. The story has to be told. The record has to be made. But you also want to be smart about not bringing the case that was going to make bad law in the Supreme Court. And there are lots of examples of that over the years. The most famous, maybe in the LGBTQ area, was Bowers versus Hardwick, which went up in 1986 and upheld sodomy laws. And the Supreme Court was on the record for saying you could put people in jail for being gay for the next 17 years, which was not good. And so the lawyers have to be both smart, but also willing at times to just fight. So there was a big debate last year about should the issue of whether Tennessee can ban gender affirming care for minors be taken up to the Supreme Court, and ultimately it was taken up. People felt like they didn't really have a choice. If the states were allowed to start these bans when we don't fight, then what are we here for as organizations fighting for trans equality? And the case was lost to the Supreme Court, and a lot of people said maybe we shouldn't have fought that case there. But it's a hard decision to make in the world that we're occupying right now. But I still think it's a fight worth fighting.
If I could just say, Paul, thank you so much for saying that last part. It is part of the strategy, as Brooke was talking about earlier. Sometimes the strategy is not to bring that bad case in court. That doesn't mean you can't continue to fight it in different ways and get prepared for it and see what's happening. I'm seeing that a lot. One of my mentors is Brian Stevenson, and we talk about this a lot as it relates to death penalty
That's
cases.
a pretty good mentor you got there,
Oh,
Demario.
very blessed, man. He wrote, I'm gonna see him on March 31st. He's opening up a new center. But we talk about this all the time, particularly in a death penalty standpoint. Like right now, going up to the Supreme Court, is a tough thing to do, and you may create bad law. So that's part of the strategy that Brooke was talking about earlier, but that doesn't mean you can't fight in other ways and prepare the record in other ways.
Right, and we had an earlier panel today about state courts and state law, and that is often an alternative way to fight. And the one thing is, even if you lose in the state Supreme Court, you're not making national bad law. You're only making one state's state constitutional bad law. And there are places where cases can be won right now in the state Supreme Courts. We had a case recently at the Campaign Legal Center where they ungerrymandered the congressional map and created a seat for the Democrats to be elected to Congress from Utah, which is not bad for the state Supreme Court of Utah.
Right.
So there are things that can be fixed if you're careful about it and you find the right approach.
Well, listen, y'all come to Oklahoma and help me fix it. We got a lot wrong down here.
Well, I thank you all for these have been compelling remarks. This discussion makes clear that appellate strategy is not simply about legal precision. It plays a pivotal role in shaping both legal doctrine and the real world reach of civil rights protections nationwide, and is central to ensuring accountability and consistency in how those protections are realized across the country. And so I'm going to ask each of you a question that, taken together, these discussions underscore a central truth that civil rights work cannot be confined to any single lens. It operates across multiple dimensions, from individual harm to systemic impact, from historical injustice to present day advocacy, and it demands that we engage each of these fully. And so this means addressing individual experiences, reckoning with historical harm, and deploying strategies capable of achieving national impact, our biggest hope, all in service of building systems that are fair, accountable, and just, and advancing meaningful, lasting change. And with that in mind, if you had to give one piece of advice to a lawyer who wants to move from handling a single civil rights case to making a broader impact, whether at the community or national level, what would it be? And I will start with you, Brooke.
Okay. So what I would say is mentorship. This type of work can be very lonely. The road is hard. And there's so many twists and turns in terms of how these courts are evaluating the law. You have to stay in touch with people who can also give you direction, people that you can learn from. You can't be afraid to reach out for help in this work because, as Paul stated, you want to try your hardest to avoid bad precedent. Venue is important. There's so many avenues to being successful, but you can't do it alone in this work because, number one, you have to have the stamina, but you also have the undergirding of people that can support you and lift you up in the times where it gets really hard and you feel that there's no hope, because a lot of these cases will have you feeling that there's no hope. You hear Attorney Crump, you see him in the media, but trust and believe that these cases are still hard fought. There's nothing given when it comes to civil rights litigation, whether it be 1983 cases or employment discrimination, so you have to reach out and don't be afraid to do it. It's a community when it comes to civil rights litigation, because there are certain types of people that want to be engaged in this work. And it's not always profitable work, but it is impactful work. And so I just encourage anyone out there who wants to figure out how to have broader success or impact broader community, reach out. Don't be afraid. Put your pride aside, and have those relationships with people who can give you even more solid footing and foundation as you continue the work, because the work is out there. We need you, and we need you to be energetic, and we're here to help. So I thank you for this opportunity to share, and I'm available as well, Brooke and Ben Crump. I'm just one person though, but there are just so many people that can be beneficial in this fight. And so that's my offer of advice.
Okay.
You want me to go next, Dr. Swan?
I sure do.
Okay.
Absolutely.
Well, first of all, thank you, Dr. Swan, for your excellent job in moderating this panel. I would say three things. Number one, I just want to reiterate what Brooke said, that do not take on, if you don't know how to do this type of case, it's too important, do not take this on yourself. Call up someone that's in the field who knows how to do it, and connect with them. Number two, one of the things I'm proud of how I've been able to structure my practice is that I've been able to work with a lot of large national firms people who are looking to get involved and do something meaningful. I mean, Squire Patton Boggs, McDermott, Wild and Schulte, Beveridge and Diamond, Gibson and Dunn. These are all firms that I'm actively working with right now on litigations across this country. And because they have people in these big firms and you're looking for a way to get involved, connect with civil rights attorneys, connect with organizations like mine, Justice for Greenwood, a Paul's organization, who need this type of resources and support. And thirdly, because my time is short, I would invite you to go to redeemernationbook.com, get my book that's coming out May 12th called Redeemer Nation. It's redeemernationbook.com, where I talk about all of this much more in depth and tell the story of how we're actually making wins here in Tulsa. We won $105 million a trust for our survivors and descendants. We got the DOJ to do the first ever investigation into the Tulsa Race Massacre. We made a citywide holiday for the Tulsa Race Massacre Remembrance Day. We're winning cases for these Black Creek Indians, and there are specific ways of doing that. So just a shameless plug, go to redeemingnation.com, redeeminationbook.com, and you can learn more about this.
We love that. Congratulations.
Yes,
That's great.
congratulations to Mario. Paul?
Dr. Swan, let me just throw in a word about reaching out, which I think the term Brooke used correctly, and Mario too. Reach out to, the key thing is to reach out to the organizations out there that are leading the fight on the issue that you're interested in. And there are racial justice groups like the Legal Defense Fund. There are LGBT groups like Lambda Legal. There are women's rights groups. The ACLU has departments that covers virtually all of these issues. And those are the people who work in those organizations who passed up the big firm salary and decided to devote their lives to a particular set of issues they care about and have the broader perspective of strategy. These organizations try to work together very effectively as often as possible and make decisions about what the right next move ought to be. And they're just filled with expertise, and they're looking for litigation capacity to pair with, as Demario was saying. So the partnership between a good litigation shop and a place where these kinds of expertise exist, it can be very, very powerful and produce systemic change even in a fairly hostile environment like we're living through right now. And it is a way in which you can go from doing a single case to multiple cases, because what you end up with is lawyers who are really happy to be working on a regular basis with that particular organization, become expert themselves. And that's a very positive and healthy way in which the bar works to achieve the best outcomes that can be done. Now, sometimes the answer is not going to be litigation at all. And it's important, I think, to understand that there are other ways to fix our democracy, to fix a lot of the problems in this country. And so, for example, on the gerrymandering and voting rights stuff, my own view is ultimately we just need a Congress that will actually pass a law that we came very close to passing in 2022 to fix a lot of those problems. With the Freedom to Vote Act, there was the John Lewis Act as well. They were kind of paired together, and so much could be done that way if we had a set of people running this country who actually want to solve these problems, and the courts can't shut that down. So there are different ways to work, different kinds of skills to bring to bear, but those organizations are the ones that know which is the right way to go at any given time, and I really commend you to depending on them as advisors and places to learn.
So as we move forward with this conversation, there are one of the questions we have, and it's specific to elderly nursing facility residents. But I think if we broaden the question from, how we deal with the low quality or what have you around nursing facilities, but maybe give the question a broader context in terms of what could some of the civil rights litigation issues be around nursing care and nursing facilities and health care in today's environment?
Well, one thing you could look at is a 1981 claim, a contractual claim. If you're making the claim that, particularly if you're talking about African-American not getting the type of care, you can, if you're talking about in a civil rights standpoint, usually that's more in a negligence standpoint. I've handled those cases before, but if you're looking at a civil rights lens, 1981 is the first thing that comes to my mind when you're talking about discrimination based upon race. But I wouldn't necessarily, if you don't have to bring a civil rights case, I don't advise you to do it. You're complicating things unnecessarily if you bring it in civil rights claims, particularly in certain venues. Now, maybe if you're in Connecticut or Chicago or some places in California, maybe that's a good deal, and you can bring a civil rights claim under state law. But like in a place like the South where I am, you're bringing in civil rights claims. That's just going to complicate things. So I wouldn't advise that unless you absolutely had to do that in a nursing home claim.
Well, an alternative would be to try to not focus on race in that kind of context. But if there's any kind of public involvement in operation of this facility, you have constitutional limits on how bad they can treat people who are in their care and custody. And you can bring a case to that effect as these kinds of institutional reform cases have been brought for all kinds of public facilities over the years where there's just insufficient care, insufficient resources, negligent care, harm being inflicted on people. And those are cases that are extremely difficult to win. But one of the things that they do is they bring all this facts to light. And your best friend often in those kinds of cases is the press, who are very interested in being able to do an expose of all the stuff that you've uncovered. And sometimes that really can lead to a kind of institutional settlement where money is devoted to making the improvements. And often the people who run those departments of state government, if that's who the defendants are happy to get the resources and happy to not feel like they're doing a better job. But there are ways in which you can use sort of basic constitutional minimum due process care standards in that situation. If there's a public role, now if it's a private nursing home, that becomes more complicated.
Thank you for that, Paul. Now, if we were to go to an area that we touched on, but we didn't really delve into, and that is how does the media play a role in a broader sense in helping to tell the story? Tell the story of the individual, but tell the story, let's say, about injunctions, tell the story about whatever. How do they help us become, or how do they help educate and inform the very communities that we need to support the civil rights work and the agenda that we need, whether it's voting, whether, we need them to go to the polls to support what we know is important, whatever. How do we use the media or have the media's voice, the narrative that we need to have considered by the broader community?
Well, I know the way that, when it comes to Ben Crump law, those cases that are egregious enough that shock the conscience, we get out early in our relationships with the media. And in doing so and being able to craft your narrative and provide the facts that we have related to the harm, with those facts being egregious enough, they tend to have interest and want to dig even deeper. And so you definitely want to have a great relationship with media and make sure that they're informed in the things that you are doing that are impactful in your community. And so I think that once you establish that, your credibility in terms of, this is, actual harm or whatever the case may be happening, engaging the media is so important because once they're interested, and interested in the right way, you direct them to where you want them to go. They'll start to follow behind you and get the information, get even more facts, and even continue to engage you on those issues. So the media is very important and often critical at times, even when your case may not be as great a case as you think it is. The media can truly be a benefit, but you just must be careful because they also, they're smart people and they do research. So you just want to make sure that your facts align with the law. And that the story that you're telling is a credible story as well.
And Paul, from the national perspective, we're talking from the systemic perspective. How does the media play a positive
Well,
role?
the courts, and even specifically the Supreme Court, very often is influenced in its view of the Constitution by what the American people think about an issue. And so the issue of marriage equality is a classic example. It was fought out over a period of about 20 years, most of it in state court, trying to avoid the Supreme Court. And over time, the public began to see this issue in a different way because of a very carefully orchestrated PR and press strategy accompanying these state court cases which basically began to educate people that if there's a gay couple down the street and they've gotten married and their kids are better protected and they're better protected, who is harmed by any of that? They're still going to be living there, whether they get marriage equality or not. It's just the sum total of human happiness is improved if we treat everybody fairly and equally. And the public opinion on that issue, which was started in around 30%, over the period of 15 years, went up a point or two for support every single year like clockwork, and to the point where the Supreme Court in 2015 was willing to tackle this issue and knew that the American people were not going to be either surprised or appalled by the recognition of a constitutional right for everybody to have the same access to marriage in all 50 states. And so it proved there was a very muted negative reaction to the decision because the groundwork had been laid over a period of time by national movements that recognized they weren't going to win this issue just by writing good briefs. I like to think the briefs are important too, but what really matters just as much is are the American people in sync with the notion that this is a core constitutional value of the country that ought to be recognized.
Can I just add just to echo what they both stated, is it's very important to try to have these relationships with the media members in your community now, like become friendly with your media members, sponsor things, go to have associations, but always remember, and that's what I tell my staff all the time, the media is not your friend. They are a tool to be utilized in your toolbook. So just always remember that. They're not your friend. They will turn the story on you in a moment if it makes better eyeballs for them.
But it can be a very useful tool in the toolbox if you're
Absolutely.
careful with it, that's for sure.
Absolutely. Yeah. Be friendly with them, but know that they're not your friend, just like a politician.
Right.
And we are going to step away from that. There are questions from several members basically asking about mentorship and whether or not either of our panelists are willing to be mentors. And if so, we would probably ask those who are asking to put their information or send their information to our staff or to our team, and we can give it to our panelists. If you want to put your name and your information in the chat, that's fine too. But the question one is from New York in terms of what advice would you give a recently barred attorney looking for work in civil rights litigation and mentorship in the New York tri-state area? And the other is from another member of the audience who is asking just generally about mentorship being given, again, to a relatively new attorney who wants to get into civil rights law practice. And so we have a link in the chat. Mentorship requests can be shared with CRSJ at americanbar.org.
Yeah, you can also go on LinkedIn. For me, if you want to send me a DM on LinkedIn, Demario Solomon Simmons, I'm happy to respond there to that. If you're on IG, Attorney Demario, just hit me up. But LinkedIn is probably the best way. Or if the ABA is going to get us that, would love to do that. See if I can connect you with some folks up in New York. Be happy to try to make that happen.
Yeah, I get asked all the time by young people coming out of law school, how do I get involved in civil rights work? It's not the easiest thing to do because a lot of people want to do it, and you could start your own firm, but that's a real challenge. And then the alternatives are not as many as you'd like. But one of them is a lot of these organizations that I was talking about have fellowship programs for young recent law graduates, where you can work there for a year or two, get to know the operation, get to know what the issues are like in that field. Another pathway, of course, is to actually learn how to be a good litigator and then go back and tell these people, I want to do some pro bono work with you, and get to know them that way. And it's not at all unusual for somebody who's maybe a 6 or 8 year litigator to be working with those organizations and end up moving over and joining them. So there are various pathways, but the key is to get linked up with, I think, the organizations one way or the other, either through an early fellowship or through pro bono work later on. That's usually the answer I give people. There are other options, of course, in other times, like going to work for the Justice Department. I wouldn't recommend that right this minute.
Right now.
But maybe in another.
And doing Brooke talked about doing how she saw someone she wanted to work with, and she had the courage to go and talk to that person and say, "I want to work with you." I mean,
that's very impressive, isn't it? Yeah. How do you do
that's
that?
what it takes. That shows you she has the heart of a civil rights attorney. She's willing to take a risk.
And I'll just say this too, as
willing to do
Paul
that.
mentioned about the organizations, like I had no clue how to even, meet Attorney Crump, but I knew that if I started doing work that aligned with civil rights, that there could possibly be an opportunity somewhere that I might connect with him or someone like him. But when I worked in the public defender's office, that gave me litigation experience. It was maybe not the highest paying, but it was experience that I needed to have so that I could sell myself later on to get to the places where I needed to be. So don't be afraid of those jobs that may not pay as much. It's just a step for you to get to the place that you want to be. And certainly I'm happy to connect with anyone and even connect you with people in your area as well. So there are so many ways to go about this, but it is about courage and creativity when you begin and when you're in it. So
And do not neglect the value of just that kind of exposure to basic litigation that Brooke was talking about, because that makes you a much more valuable lawyer than you are coming out of law school. Well, law schools do many things, but teaching people to be litigators, they really don't. Maybe they start, but there's a long way to go for people I know coming out of law school.
yeah,
100%.
Absolutely, from theory to practice.
that's right.
So there's a conversation about the media, going back to the media in terms of, in light of the administration's attacks on the media's free speech and freedom to cover issues without any type of consequence. What do we expect to get from, what can we expect from the media, given the attack on their ability to be objective in their approaches, as well as, I would take it one step more, just generally in the work that we do, and how we're finding that many attorneys are now hesitant to move in certain directions and push certain areas of the law because of the administration's attacks. Do we have any thoughts on that?
Well, obviously, the media is a complicated mix of different things. Some of the media has been captured, some of the media has been deterred, but there are a lot of good journalists out there still willing to tell the truth and put themselves on the line. So you really have to find the right one with the right outlet, and hopefully you have, if you're in Tulsa, hopefully there's somebody perfect for that role in Tulsa that Demario can point you to, and wherever it might be. In terms of law firms, my sense is that the legal profession is stiffening its spine a bit now, and as it sees the challenges ahead, and at least I'm hoping so. That people are being more willing than they were a year ago to challenge abuses of authority that they're seeing, and I think that they're recognizing ultimately that there may be a business case for doing that as well as a moral case, and at least that's my optimistic view of the larger law firms and where they are at the moment, which may or may not be fully accurate, but I hope it is.
Well, in the context of civil rights attorneys, like I don't have any faith in the corporate media because it's about profit. But I believe, as a civil rights attorney, I believe that's a calling. When I say law is my ministry, justice is my passion, that's what I mean. And that's what I'm saying, to get in this space. This is the time, and Thurgood Marshall is one of my heroes. You think it's hard for me now? What was he dealing with? And so this is the time, if you say you're a civil rights attorney, if you say you're about this life, this is the time to prove it. This is the time to prove it. Not under Obama, not under Biden, not under all these times. Today is the time to prove if you're really about civil rights works and protecting the least of these, as Brooke said from the very beginning. This is the time to prove it. And I intend to do it, and I'm hoping others on here will join me, Brooke and Paul and I.
And what I'll mention too is that what we're seeing is a lot of media folks becoming independent of sorts. So our hope is that they continue to tell the stories that we want them to tell because they're not beholden to corporate media, because that is becoming more and more a challenge. But again, I can't echo enough. This work is not for the faint of heart. Attorney Crump always says, if you're scared, say you're scared, because this may not be for you. But if you truly feel like you're ready to impact and you want to impact, then there's nothing like just, reaching out and finding that opportunity to get busy. Yep.
And I always say that to young people that if you're not excited about the prospect of being a lawyer in this time and trying to use your skill to do something right now, you're going to look back later on and say, why wasn't I doing it? This is when it needed to happen. So I'm with Demario and Brooke on that.
Exactly. And Demario, there's a question in here that I believe you answered at some point around your reparations case and the winning of it and some of the strategies. I want those that are asking some of the questions to understand that we will make certain that the panelists receive these questions, and we'll get back with you with answers. There's several questions that are going back to the nursing home abuse and neglect and tort cases around that. And so we will make sure, Ms. Shirley, that we will get back to you on those questions that you have. I don't want anyone to think that we're avoiding the questions that are here. Ms. Kloos, there are questions around the Ben Crump law firm and family separation cases. That it's a broad question around who's protecting the children. And I'm going to make certain that you get those questions as well, in terms of what institutional abuse looks like and how we can move forward with some of that. So with that in mind, I want to close this out by thanking our panel for an amazing conversation, for sharing their expertise, and to everyone who joined us today, live or on demand. If you found today's discussion valuable, we encourage you to share the recording with your networks and explore other upcoming programs from the section of Civil Rights and Social Justice, again at americanbar.org/CRSJ. As this is the last panel of the day, this will close out our day. So we wish to thank everyone for attending, and please be sure to join us for day 2 on March 27th. And at that time, we will discuss voting rights, retaliation at work, tangled web of the First Amendment protections in education, and unlocking impact around pro bono paths and immigration justice. So please consider joining the section. Go to our website to find out more about our initiatives and committees. We need all of you. Again, thank you to this amazing panel. And any information you need, please email the CRSJ email address that was given to you. We will follow up and make certain that this panel gets any information you want to have given to them. So thank you again for being part of Civil Rights Bootcamp 2.0. And we look forward to hopefully you joining the ABA in the section. Thank you so much.
Great job, Dr. Swan.